So what happens when a moment of pure panic leads to a split-second decision, a decision that could actually land you with a criminal record? Well, today, we're going to break down the charge of destroying evidence. We're using some great insights from a legal services blog to really understand the law, what the consequences look like, and, importantly, what the potential defenses are.
I mean, just picture it for a second. You see those flashing lights in the rearview mirror. The stress of dealing with law enforcement it's intense. In that super high-pressure moment, your mind is just racing. It's one of those situations where your gut instincts can totally take over.
And what you choose to do in that split second, maybe out of fear or just plain confusion, can have some seriously big legal consequences. And that's exactly what brings us here today, this very specific charge of destroying or concealing evidence.
All right, so the law we're really zooming in on is California Penal Code 135. So let's get right into it. What does it actually mean to be charged with destroying evidence?
Okay, so at its core, this law is all about the intentional act of hiding or destroying something that could be evidence. Now, the prosecution has to prove two big things: that the act was willful and that the person knew it was evidence. And honestly, that's a pretty high bar to clear. And this isn't some kind of high-stakes movie plot stuff. As you can see from these examples, this charge can pop up in really normal, everyday situations. We're talking about things like tossing something out of a car window or quickly deleting a file on your phone when you realize police are nearby. So the whole thing really hinges on one crucial word: intent. For someone to be convicted, a prosecutor has to prove that you knew an investigation was happening or was about to, and that you deliberately tried to get rid of something. Accidentally dropping your phone and cracking the screen is a whole different world from smashing it on the pavement to hide what's on it.
Now, even though it's classified as a misdemeanor, you might be surprised to hear that a conviction under Penal Code 135 can carry some pretty significant penalties.
First off, there's the possibility of jail time. Yeah. Depending on the details of the case and, any prior record, a judge could sentence someone to up to 6 whole months in county jail. And on top of that, you're looking at financial penalties. A conviction can also come with a fine of up to $1,000, which just adds another layer of stress to what's already a really tough time.
But the consequences don't even stop there. A conviction also means you're looking at informal probation and, this is the big one, a permanent criminal record. And that record, it can follow you for years, making things like getting a job, applying for housing, and even getting professional licenses so much harder.
Okay, so you've been arrested. What happens now? Well, the very first hurdle you're going to face is the bail process. That's the first step to getting released and starting to actually build your defense.
The whole thing is pretty standard, really. After you get booked, a bail amount is set. At that point, a lot of people get in touch with the bail bonds agency. You basically pay the agency a fee, usually just a percentage of the total bail, and then they post a bond with the court, which gets you released until your court date.
Now, this is so important to remember. Being charged is not the same as being convicted. Not at all. The prosecution still has to prove their case beyond a reasonable doubt, and there are actually several solid ways to challenge a Penal Code 135 charge.
A really strong defense often comes right back to that word intent. Was the whole thing an accident? Did you even have a clue an investigation was happening? Or, hey, maybe the thing in question wasn't even relevant evidence in the first place. And in chaotic situations, you can't rule out false accusations or simple misunderstandings.
This quote from the source material really just hits the nail on the head, doesn't it? These charges often aren't some kind of premeditated crime. So frequently, they're just the result of a very human reaction: panic, in a moment of extreme stress and fear.
And that leaves us with the million-dollar question, right? When does a panicked, impulsive action cross the line and become a willful criminal act? That is exactly what the legal system has to figure out. It's an incredibly fine line, and understanding it is absolutely key to navigating this complex charge.